right. Welcome back to our Monday Forms Day. Today we are picking up where we left off with the residential listing agreement. Last week we covered sections 1 through 13 along with the forms that come at the beginning. Today we're going to cover 14 through the end. We'll also cover a couple of addendums, and those will be listed separately. So in addition to this, you can search for forms and do the mobile home purchase addendum or manufactured home purchase addendum, same thing. And then also the probate purchase addendum. So a couple of things that you may need depending on your listing situation. So section 14 is where we're going to pick up photographs and internet advertising. 14A just talks about, hey, it's in order to effectively market the property for sale, we need photographs and potentially virtual tours and other media. Seller agrees to this is the default. They're on A, if they check that box, they're saying, hey, we don't want any photos of our property taken. Period. End of story. So then you've got to figure out how to market the property without photos. You may want to rethink listing that property because it's going to be really difficult to market with no photos, but it does happen. So it can. Just make sure you price it appropriately. People are going to be a little bit more leery and concerned about putting an offer in on a property with no pictures because, of course, they assume the worst. In addition to that, it's just saying that if we hire a third party, like a professional photographer, which you probably should be to take your photos, that there may be some ownership issues there with who actually owns the photos and what those can be used for. So the photographer may use those in their own dispersal, like on their website or promotion or different things like that to advertise their services. It also says that, you know, once those photos go to the internet, we have limited control of being able to pull all of those photos back and get them off the internet. So just a few things there under 14A. 14B is that seller acknowledges that prospective buyers and persons coming to the property may want to take their own photos or videos of the house, right? So that they can remember the house for themselves. If we check this box here on 14B, it's the seller instructing the broker to put in the MLS that taking images is limited to those persons preparing an appraisal or inspection reports, that potential buyers cannot. It also lets the seller know that ultimately we don't have control over what people do. We can ask them not to, but they still may whip out their phones or their camera and take pictures or videos as they go through the house. So, and then once those are taken, if they're put into electronic display, internet or otherwise, we have limited control over who views such images or what viewers may make of those images. So that's 14. 15 is the key safe lockbox. It says, hey, it's designated to hold that key to permit access to the property by broker, cooperating brokers, MLS participants, their authorized licensees, representatives, inspectors, and accompanied prospective buyers. And this is just saying that, hey, we're agreeing that it's okay to put a lockbox on our property. If you don't agree, and it also says here, in addition to that, just so you know, that sellers consent to access the property to inspectors, appraisers, workers, repair persons, and other persons requiring entry to the property in order to facilitate the sale of the property, broker cooperating with brokers, or broker cooperating brokers, MLS associations, boards are not insured against injury, theft, loss, vandalism, or damage attributed to the use of the key safe lockbox. Okay. If it's 14 or 15A, we check that box if they don't want a lockbox on the property. Okay, I'd want to understand their theory or thoughts behind that. Just know if they don't want a lockbox, somebody's going to have to provide access to that property. Okay. And you can let them know too that we use an electronic lockbox system that captures the agent's information that opens it. So we know when they've started the showing, when they've ended the showing, who showed up, who didn't show up. So an electronic system, it's not just like a combo that somebody can plug in and show up or somebody could get a hold of it. So kind of keep that in mind as well. I usually point that out to my sellers. 15B is tenant occupied property. If the seller doesn't occupy the property and anybody else except the actual seller on record occupies that property, even if it's a family member of the seller doesn't actually live there, we need to make sure that we include CAR form KLA, the key safe lockbox addendum. And that just specifies that the tenant acknowledges there's going to be a lockbox on the property and the tenant actually has to sign that form. Okay, so if it's tenant occupied, so again, tenant occupied would be anybody but the seller lives in that property, even if related to the seller, then we use that KLA form. 16 is sign. Seller does authorize broker to install a for sale or sold sign on the property. If they don't want one, we check the box that they don't. Remember, our for sale sign ultimately is a marketing piece. It helps us leverage that listing for additional leads. The properties that sell by sign are about the same as the properties that sell by open house. It's like, you know, in the single digits of percentage of properties that sell based on a sign call, but it does lead generate for us. So it's really important that we have a sign on that property that we're trying to sell so that we can generate additional leads. 17 is equal housing opportunity. It's offered in compliance with federal, state, local anti-discrimination laws. Attorney fees, any action or proceeding or arbitration between seller and broker arising out of this agreement. Seller and broker are each responsible for paying their own attorney fees and costs except as provided in paragraph 22A. Here's some additional terms. It might be an REO listing advisory if you're listing it on behalf of a bank that's foreclosed on the property. If you're doing it as a short sale, you're going to have the short sale information and advisory, the SSIA. If it's listed as part of a trust, you're going to include a trust advisory. And if the seller intends to include a contingency to purchase a replacement property as part of a resulting transaction, we would check that box there, just stating that, hey, the sale of this home is contingent on us finding a replacement property. We don't want our sellers to end up homeless if they can't find a property. So we would check this box here. Remember, this box here doesn't protect the seller once you enter into contract. So we actually need to have the contingency for this, or the seller's purchase of replacement property, the SPRP, needs to be included as part of that purchase agreement when we accept the offer in order to make sure that it is contingent on the sale of their home and purchase of replacement property, or the sale of their home is contingent on the purchase of replacement property. So checking this box isn't enough. If you forget to check this box, it's probably okay. We can just add in that SPRP form. If you were trying to go by the book, dot your I's, cross your T's, you forget to check this box, it is contingent. We would just want to come back to a modification of terms and state sale of home is contingent on sellers finding a replacement property. I usually fill out that SPRP in advance. I do it with the listing agreement so that it's filled out on the terms as which would be agreeable to my clients, the sellers. Okay, because we want the buyer to give my sellers everything they want. Okay, there's some blank lines here. This is a good place to put like agent to credit seller, the cost of professional photos and any pre-listing inspections that close the escrow. It's a really good way of having the seller pay for them up front and let them know that once we close, we'll credit that money back to them. So there's a couple ways to do that there. But that's one thing that you might find in additional terms. Okay, 20 is management approval. Again, if you're not the broker of the office, you enter into this agreement on the broker's behalf. The broker can cancel this agreement within 5 days of execution. That's why it's super important that we upload it into SkySlope within 24 hours of acceptance. Okay, you should get it over to your transaction coordinator. If you're using one, which you should be, they will make sure that happens. So you should get it done as soon as you have this signed. An easy way to do that too, just so you know, is when we go to send it out for signatures, you can add a CC signature on it, which means they get a copy of it. You add your transaction coordinator as a CC, and then once it's fully executed and signed, your transaction coordinator already has a copy of it. Magic, I know. That's one way to do it. All right, 21, successors and assigns. It's binding upon the sellers and sellers, successors and assigns. It's just saying that, hey, if they assign somebody else, it's still binding. Dispute resolution, this is that paragraph 22 that was referenced earlier. Mediation, we're agreeing to mediate any dispute or claim that arises under this agreement before resorting to arbitration or court action. Mediation fees shall be divided equally. Okay. If any dispute or claim for which this paragraph applies, the non-mediating party commences an action, right? They go straight to arbitration or court action without mediation. Or before the commencement date of an action refuses to mediate after a request has been made, then the non-mediating, and then if the non-mediating party is the losing party, the prevailing party shall be entitled to recover the attorney fees from the non-mediating party. Exclusions from this mediation are specified in 22B, which is judicial or non-judicial foreclosure. So if the property is foreclosed on, we can't go in there and dispute that they failed to sell and they still owe us or they prevented the sale of the property and they owe us a commission. It's not gonna work. Okay. Let's see here. Unlawful detainer action, the filing or enforcement of a mechanics lien, any matter within the jurisdiction of a probate, small claims, or bankruptcy court, the filing of a court action to enable the recording of a notice of pending action for an order of attachment, receivership, injunction, or provisional remedies shall not constitute a waiver or violation of the mediation provisions. Arbitration advisory, if the seller and broker, so we're only agreeing to mediation, we're not agreeing to arbitration. If you want to agree to arbitration, we would use card form ARB. What's the benefits of arbitration? Arbitration is like a court hearing, except the jury is a panel of realtors who understand real estate law and the contracts, or should at least probably understand that. So that's the benefit of going to arbitration, going from mediation to arbitration. In case anybody ever asked, that is the main benefit there, is instead of just going in front of a jury or a panel of regular everyday people that may not understand real estate law, you're actually going in front of a panel of licensed realtors. Any questions so far on 14 through 22? All right. 20.
No,
thank you. 23, entire agreement. All prior discussions, negotiations, and agreements between the parties concerning the subject matter of this agreement are superseded by this agreement, which constitutes the entire contract. A complete and exclusive expression of the agreement may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. If any provision in this agreement is held to be ineffective or invalid, the remaining will still be given full force and effect. This can be signed by photocopy, fax, and it may be executed in counterparts. So I might sign one copy, my seller might sign another copy. As long as they look exactly the same and they are exactly the same, it counts as a signed agreement, fully executed. 24 is ownership, title, and authority. Seller warrants that seller is the owner of the property. No other persons or entities have title to the property, and seller has the authority to both execute this agreement and sell the property. Exceptions to ownership, title, and authority are as follows. So let's say that we have a house going through probate, or somebody's passed away and we're just waiting for, we already have talked to the judge. We know the judge is going to award this person to be the specialized probate person that has a really special name that I can't come up with right now. We can have that person go ahead and sign the listing agreement, but we want to specify here that sale of property is pending official court order on who is the executor of the probate. That's not what it's called, but whoever that is. So, right. So we'd want to write that in there so that we know that ultimately, until that happens, this isn't 100% valid. Okay, so we can put things like that in there. Or sometimes there might be somebody that has like a first right of refusal and we're signing a listing agreement because we're getting ready to put it on the market. At the same time, the seller's also going to that person and notifying them that, hey, I'm selling the property. I know that you have first right of refusal. We may want to write that in there as well, that if so-and-so elects to purchase the property or execute their first right of refusal to purchase the property, then this contract is null and void, right? So anything like that could go under that section there. 25, legally authorized signer. Whenever the signatures or the initials of the legally authorized signer identified in the signature block below appear on this agreement or any court-related documents, it shall be deemed in a representative capacity for the entity described and not in an individual capacity. This is the same verbiage that we see on just about every contract. Right? So they have the ability to sign on behalf of the entity, and they're going to provide us proof of that within 3 days of executing this agreement. That's the summary of paragraph 25. So that would be like a trust, a corporation, whoever else may own a property. Okay. So just a partnership, whatever it might be. By signing below, seller acknowledges they've read, understands, and received a copy of and agrees to the terms of this agreement. Here's where we would check the box if it's not an individual seller, right? So normal sellers, we just skip this section. We come down here, seller one's name goes here, seller two, if there is one, goes there. We're going to fill it out, their address, right, phone number. You can fill it out as completely as you want. As long as you've got the name and the date, we're good. If it's an entity seller, we're going to check this box here, and then we're going to fill in who's the name of the legally authorized seller. Okay, and there it gives you space for a couple names there. And then if the entity is a trust or under probate, the following is the full name of the trust or probate case. So if it's an entity seller, oftentimes what happens then is the printed name of the seller goes here, right? So this would be like entity LLC. And then the printed name of the legally authorized signer would go here. We're going to put Amy Smith. There we go. See how it auto-populates? So we have the seller's name. Here we have the legally authorized signer. If they have a title, maybe they're the president, then we would put that there. If it was like a trust, then up here we'd keep Amy Smith, but over here we're going to put the Amy Smith Living Trust. And then in this entity seller, we would put Amy Smith Living Trust. And then Amy Smith, the title for a trust would be trustee. Okay. So super simple. Going forward, once we've signed this document, any future documents can just be signed Amy Smith, comma, trustee. Okay. Or Amy Smith, comma, president. So their name and their title. Okay. Same thing for seller two. If you have more than 2 sellers, we would use the ASA form, the additional signature addendum here. Down here at the bottom, it gives us a box to check for that. The ASA, it'll automatically add it to your transaction once you check that. And that's what you use for any additional sellers. So only 2 sellers sign this one. At Realty One Group Fox, we like you to have all the sellers initial all the pages. So somewhere down here, the bottom corner, the upper corner, somewhere on there, have them sign it. Oh, you know what I'm going to have you do? I'll show you this really cool because it's really neat. This is going to make people like AJ, who probably isn't watching this training, but if he did, he would be like, oh my gosh, I like this editing and the signing software even better. Because watch this. If I go prepare signing, we're going to hit create. Then I'm gonna have to go back into this. So it's going to take me a minute once I get through this, but I'm going to show you. This is so cool. I just found this last weekend. I'm always playing with things to try to find better ways to do it. But when we go into our signing, it's thinking really hard. There we go. It's waiting for it to add my document. There you go. It's adding that listing agreement. Okay. I can go add participants, add new, or you could hit add from transaction. I'm just going to put Amy. Actually, what I'm going to do is I'm going to put signer number 3. We're going to skip that for now. We're going to hit add to transaction. They're a remote signer. Oh, we can hit roll here. Seller 3. So I'm just going to select that. Oh, it's not going to let me do it without an email. So we're just going to put in a fake email, fake test email at email.com. So you YouTube out there, it's not a real email. We're going to hit save. Okay, it's going to add this signer to our folder. I just think this is so cool. So let's say we have a third person, they're going to sign that ASA, but we also need them to initial every page that they've seen all the documents. Even though the ASA mentions that they have, they're acknowledging that they have, we still like them to sign it so that we know they've actually physically like initialed each page. This is taking a long time, so it's thinking really hard today. We're going to try to wait patiently. Sometimes waiting patiently is really hard. Maybe. You can do it. Told you. Patience is hard. Let's see if I. Close a couple things, see if I can get my computer thinking faster than it's currently thinking. Nope. Still thinking. Give it a second. All right, see if we can. All right, well, let's see if it'll, oh, there we go. Okay, so when we go to tools, oh, it still hasn't popped it up yet, but so we'll just have myself on there for now. You can come down here to, oh, it's not giving me the options. So sad. Normally, oh, here. Maybe I have to accept it. It's really unhappy with me right now. No. Let's try this again. Otherwise, we may have to back out and try again. Signer, seller 3. There we go. All right. So now we've got seller 3 on there. It's going to assign signature blocks, which it's not going to find any. Hopefully it'll still let me do this. Maybe it was like a fluke thing. We're just going to hit ignore, ignore, ignore. All right. So look at right here on our options for signatures, it gives us initial pages. If I click on that, it's going to say, hey, do you want large initials, medium, or small? So I'm gonna go with medium. Do you want them on the left-hand side, in the center, or the right? And then do you want it at the top of the document or the bottom? So if I'm like, hey, I want it bottom right, we just do that. Who do we want to have to initial? So we could select all of our signers at the exact same time, set these up, and then you're gonna hit which document you want it on. We're gonna hit residential. Do you want it on all pages or just specific pages? And then you're gonna hit place initials. And this may screw it up. It seems to be having issues right now. Yeah, that's what I thought was going to happen. All right, hold on. Let me re-pull this back up. Maybe it'll do it. I don't think it's going to. All right, hold on. Anyways, you hit that button, that initial all, and then you select the placement, you select who you want to initial, you select which documents you want to initial them on, and which pages of those documents you want them to initial on, because like if there's a signature on one page, they may not need to initial all of them. And then you just hit apply and away it goes. It's like magic. It's like magic. So no longer do you have to spend countless hours assigning an initial block to every page of different things. You could just throw them on there just like that. So anyways, I think that's magical. So there's your little bonus item for today. I'm reopening it up here. All right, we are back to this. We're going to go back to the test purchase because I unshared my screen. I have to reopen all the windows while it's doing that. So anyways, that's how you assign signature blocks to each and every page. That alone was probably worth you hopping on this training. I had to send, there was some additional agreements on a offer that I had the other day that I just wanted the seller to like, so generally when I get an offer in on one of my listings, you usually get like a lender letter and proof of funds. And I usually have my sellers initial those pages, showing that they've seen those documents. So, right. Or like the contingency removal, the buyer signs it if they're removing contingency, but the seller doesn't. So I might have 4 or 5 forms in there that maybe don't get a signature, but I want them to be initial. That's one way to go in there and do it. You can just go in there at the end, you settle the signature blocks, then you go in there, all the pages that need those initials that don't normally get initials, you just select it and it'll pop it on there for you. So super handy tool. Sorry, ultimately it aired out there on showing you, but we were really close. So I'm going to go back to the listing agreement here. Get that reopened back up. And in case you didn't know this, in your forms editor, you can select multiple forms like that, hit open in forms editor. It's going to open all of those forms. It also will usually ask if you want your previous workspace open or a new one. I don't know why it didn't ask this time, but it didn't. That just means if you want your previous workspace open, because we're already being pushed to the new sign or the new editing, which you should have been using anyways. It's just going to open whatever you had open previously. It's going to reopen all of those documents together. All right, so we were at the end of the residential listing agreement. There's the end of it. Everybody signs. We talked about that. This is where you're going to sign. It says broker signature, but it's going to be brokerage name, license number, address, city, state, and then whoever's listing the property goes here. So that would be your name, telephone, email, and your DRE license number. If you're co-listing a property with another brokerage, number one, get prior approval before you do that, please. Number two, check this box here. You're going to include the form, the ABA, the additional broker acknowledgement. You're like, Amy, why would you ever do that? Maybe you're co-listing with an out-of-area broker. They're like too control freaky to just refer the client to you and let you handle it, but they want to co-list it with you. Maybe you're doing all the foot on the ground stuff locally. They're doing all the paperwork. So you're getting some sort of split with them. You just want to make sure that that's okay with your brokerage. And then you're going to check that box and it just identifies there's two separate brokerages. Sometimes you might also do that like in a case of a divorce or something where maybe the husband trusts you and the wife trusts a different agent. You guys are going to work together on getting their property sold. You can do it that way too. The seller's advisory, super important. It talks about the sale process in the state of California, and that it involves many steps. It could take anywhere from a few weeks to months, depending on the condition of the property, local market conditions, other factors. You're already taking the important first step by listing with a licensed real estate broker. We're going to help you walk through this property. And then here are some things they need to be aware of. The general disclosure duties, right? This is statutory disclosures, the NHD report, providing the booklets about like earthquake safety and lead-based paint in the home and all of those environmental hazards. They need to disclose if it's located within a mile of military ordinance, and you can let them know, hey, all this stuff is going to be taken care of. We hire a third-party natural hazard zone disclosure company that's going to disclose all this stuff for you so you don't have to worry about it. In addition, TDS, NHD, lead, fire hardening, defensible space, military ordinance, commercial zone, tax disclosures, they have to deliver those documents as well. Other things they must disclose, like death on the property, right? We only have to disclose it if it's been within 3 years. Okay, some other things that we have to disclose, regardless of date of occurrence, right? Where the date has occurred more than 3 years prior to the date the transferee offers the purchase, lease, rental, or rent the real property, or regardless of date of occurrence, that occupant was a property affected with or died from, that's HIV. This law does not immunize an owner or his legal agent from making an intentional misrepresentation in response to a direct inquiry from the transferee or prospective transferee of real property concerning deaths. So right on the disclosure, it's 3 years, but if the other property or if the other agent says, hey, has anybody died? Or the buyer says, has anybody ever died in this property? If you know it was 5 years ago, they ask you directly, you do need to answer that. They have to disclose whether it's in a condo or a common interest subdivision, and then contract terms and legal requirements, withholding taxes. They may ask for repairs or other items. The seller's decision to comply or not comply. We can't discriminate. There might be government required repairs and alterations. We need to discuss who's going to take care of those. The EPA's lead-based paint renovation, repair, and painting rule room, the RRP, right? So if it's before 1978, they must follow protective work standards. There you go. Legal, tax, and other implications. You should seek professional advice, basically. Marketing considerations, pre-sale inspections, and considerations. Here's a really important one. Pre-sale inspections and considerations. You should consider doing what you can to prepare your property for sale, such as correcting any defects and or other problems, making cosmetic improvements, and staging. Many people are not aware of defects in or problems with their own property. One way to make yourself aware is to obtain a professional inspection prior to sale. Pre-sale inspections may include a general property inspection, an inspection for wood destroying pests and organisms, or an inspection of septic or well systems, if any, among others, right? By doing this, you then have the opportunity to make repairs before it's sold, which may enhance its marketability. Keep in mind that any problems revealed by such inspection report or repairs that have been made should be disclosed to the buyer. Right? Even if the buyer gets their own inspection. So there's just some cool things there. Talks about post-sale protections, and then also safety precautions, like for sale signs, disseminating photographs, videotapes, all that stuff. So that's all part of that seller's information advisory. Also attached to that listing agreement is your California Consumer Privacy Act disclosure and notice, basically saying that California has a California Consumer Privacy Act, and then also saying that basically in the real estate industry, like, it really doesn't apply. But they can obtain more information about their rights here at that website. The next form. Any questions about the listing agreement before we end that for this quarter? Listing agreement, sections 14 to the end, and then the associated forms with it. All right, fabulous. We're going to move on to our next form. The next form that we are covering is our probate listing addendum and advisory. This would be if the property you're preparing to list is going through probate or has been through probate. The following terms and conditions are hereby incorporated and made part of the residential listing agreement. We're going to check this box here. If you didn't catch that it was probate when you drew up the listing agreement, we would do a modification of terms stating that it is a probate sale, and then we would include this form. So you might reference a modification of terms here versus the residential listing agreement. For the most part, though, it's going to be that RLA. You would put the date in the upper left-hand corner of the first page of that listing agreement. On ours, it would have been last Monday. Here, you're going to have the seller's names. Here, you're going to put the broker. So that would be us. Nope. Realty One Groove box. There you go. The property is part of a probate estate, or if checked, conservatorship, guardianship, or receivership. So if it's one of those, we're going to check that box. Otherwise, we leave it default. The listing period shall be the shorter of 90 days or the length of time specified in the listing. So max is 90 days unless we only have a listing agreement of 30 days, but we can always extend it as it gets closer to that expiration period. Court confirmation of the sale is required or may be required. So has the court already agreed to it? Have they not? Do we have to ask the court for permission? That would check which box goes there. Information about this listing will not be provided to the MLS specified in the listing, right? If it's not going to go on the MLS, we would check that box there. So for the most part, oftentimes the time we get here, we may already have the authority to sell the property. So we would put maybe required. And then information about the listing is going to pass on. Compensation specified to broker and any other cooperating broker is subject to any restrictions imposed by California Probate Code and the determination of the court. The dispute resolution paragraph is deleted in its entirety if the property is under Independent Administrative Real Estate Acts, IAEA, and the parties are attempting to modify the agreement to include any of these provisions. The parties are advised to seek counsel of a qualified California probate attorney before adding such provision. So dispute resolution paragraph doesn't apply. Probate advisory is attached to this agreement. Okay, so this is the probate listing addendum and advisory. You would also do the probate advisory that you give to the buyer. Notwithstanding any term in the listing to the contrary, seller warrants that the title to the property is as follows. Okay. Title is marketable, title is clouded, what is it? Foregoing terms and conditions are hereby agreed to, and the undersigned acknowledge a receipt of the copy of this document, right? It's just outlining how this process is going to roll and what approvals we still need. Seller sign, and then the you sign here under the brokerage. Any questions about that probate listing addendum?
No, ma'am.
All right. Attached to that form again is that probate advisory. This again is going to be between the sellers and the buyers. So I would go ahead and have my sellers initial it at the time of the listing agreement and at the time they sign the probate listing addendum and have them sign the bottom. And this is just going to outline to the poor buyers that this property was a probate or a guardianship or conservatorship or receivership. The sale may require court order. Many obligations are imposed, right? So exemptions, they're exempt from the TDS, the NHD, and the Melrose. Seller is exempt from providing buyer with the transfer disclosure statement, the natural hazard disclosure statement, and a Melrose district land. Now, for the most part, just so we know, we have our sellers complete the exempt seller disclosure in this case, where it talks about the fact that they're exempt from that disclosure. We are still going to order and provide to the buyer an NHD report. Even though they're exempt, we're still going to provide that for the most part, because there's other things that they may still be required to provide that's in those documents, including all of those booklets and stuff that need to go to the buyer. Okay, earthquake guide, sellers exempt from providing an earthquake guide to homeowners. See, that's one of those that they don't have to provide. Smoke detectors, the seller is exempt from the state requirements that for single family residents, operable smoke detectors be in place and that a written statement of compliance be provided to buyer, which means we don't have to provide the smoke detector statement of compliance. Usually we do a water heater smoke detector, it's a WHSD form for the water heater and the smoke detector. You could just use, there's one that's separate, that's just the water heater statement of compliance on a probate sale. We don't have to use the smoke detector statement of compliance. Now, keep in mind for a loan to be issued on the property, the lender is going to require smoke detectors. Okay, so it might be a conversation we need to have with the person executing this probate of, hey, just so you know, under California law, because it's probate, you're exempt from smoke detectors only, not carbon monoxide, not double strapping your water heater. However, for a buyer, you're going to limit your buyer pool if the buyer has to pay for and install smoke detectors if you don't have any. Like we don't have to do the form, but you still may want to make sure those are in the house, right? So we may want to have that conversation with them. Same thing about like the NHD report, like, hey, you're exempt from the NHD disclosure. However, the NHD report's way more comprehensive and provides additional details of things that still have to be disclosed that are outside the NHD. So we may want to go ahead and include that just to protect you. Okay. Requirements, the seller is not exempt from the common law and statutory duties concerning fraud and deceit. Right? Even though the TDS is not required, seller remains obligated to disclose known material facts. Hazard zone, seller is not exempt from the applicable statutory obligations to disclose earthquake fault zones, seismic hazard zones, state fire responsibility area, very high fire hazard severity zones, special flood hazards, right? All these things are in that NHD report. That's why we still order the NHD report. Okay. Flood hazard zones, government code, United States code, even though pursuant to civil code, the specific NHD form is not required to be completed. So we do the NHD report. Water heaters, the sale is not exempt from the water heater being properly anchored and braced or strapped. They're not exempt from their obligations for lead-based paint hazards if the property was built before 1978. They're not exempt from making sure that the property has carbon monoxide detectors. Remember, those are going to be on in the hallway to the bedroom. If there's more than one story, there should be one on each floor. The only time a property is exempt from the carbon monoxide is if it does not have an attached garage, it does not have any gas related appliances, no natural gas on the property, and there is no fireplace. If all three of those things are true, no fireplace, no attached garage, and no gas appliances or no natural gas in the property, then you don't actually need a carbon monoxide detector. Those are your carbon monoxide producing elements: attached garage, fireplace, and gas appliances. Okay. Megan's Law, they're not exempt. It's part of the purchase agreement, so you don't have to worry about that. And then the notice regarding gas and hazardous liquid transmission pipelines, again, that's going to be in that NHD report. Tax withholding, they're not exempt from providing a FERPTA form. Brokers, we're not exempt from providing our AVID, our agent visual inspection disclosure, and we're not exempt from our obligation to disclose agency. Okay, other considerations, local law, if the property is being sold, right, there may be requirements on the house based on local laws, right? If you're like in Davis, you have to provide your pre-sale inspection by the city and have all those items taken care of that are noted, or pass it off to the buyer and they have to take care of them within 30 days of close. In the East Bay, there's things like sewer lateral inspections. In winter, or in Woodland, there are sprinkler inspections that have to be done, fire suppression system inspections if it has one. If the property has been sold under the authority of probate because of a death of an owner of the property, buyer has concerns about the manner, location, or details of the death, the buyer should direct any specific questions to the executor or administrator of the estate. Administrator of the estate, that's what I was looking for. Stock, it's got to disclose if it's in a co-op. We don't have very many of those in the area. Court jurisdiction and authority, this is just court confirmation, independent authority. It's going through that the court may or may not approve the sale. Liquidated damage, that they're not bound by independent agreements to liquidated damage, and limit the ability of the buyer's deposit, limit the applicability of the buyer's deposit if buyer defaults. Liquidated damage clause shall be excluded from the parties' agreement. So if we have a probate sale, we should not agree to the liquidated damage clause because it's saying right here that it doesn't apply. Mediation, they have jurisdiction over the resolution of disputes arising out of the probate process. Mediation shall be executed by the parties' agreement. That's on the probate purchase addendum, or the probate addendum. Arbitration of disputes, probate courts have jurisdiction over the resolution of disputes arising out of the process. So the arbitration clause shall be excluded by the parties. So again, on our purchase agreement, when we receive that as part of a probate, we don't want to be agreeing to the liquidated damage clause or the arbitration of disputes. Okay. Any questions about that probate advisory that is attached to our probate addendum, our probate listing addendum?
No, ma'am.
All right, so remember, probate listing addendum and advisory is between us and our clients, where the probate advisory is between a buyer and a seller. So usually you have that seller sign it up front, and then the buyer can sign it at time of offer. Okay. Fabulous. The next one that we may need to include, which we seem to be seeing a lot of these, especially in our office, is our manufactured home listing addendum. We're seeing them more on the purchase side, but if you're managing those clients well and taking care of them, eventually they'll want to move up and out and sell that mobile home or manufactured home and buy a better property. Not that there's anything wrong with manufactured homes, because there's not, but sometimes they're in a park. They may want to like move up to a regular house, although a lot of times our seniors actually move down into mobile homes. So there's always a place and a time for those. And a mobile home or manufactured home, we use this whether it's on a park or whether it's on real property that they're actually buying the land. So it might be like a property with a mobile home on it versus a mobile home in a park or a manufactured home. The following terms and conditions are hereby incorporated and made part of the listing agreement is the default. You're going to put the date in the upper left-hand corner of that listing agreement. Property address, put it there because I haven't mentioned it in a little while, like 3 forms at least. Make sure you put the full property address, 123 Sample Street, Drive, Road, Court, whatever that is, because sometimes duplicate addresses on a street and a court, city, state, right? Zip code here, you're going to put the sellers' names here, and then you as the brokerage go on that next line. Section 1 is the type of manufactured home. We're going to check applicable box below paragraphs A1, A2, or B. You're only going to check one box. They even made sure to say that right here. It's either a manufactured home on leased or rented land. So that would be like a space number in a park. Okay, that would be section A, at which point you're going to put in the space number, the park name, the park address, the city, the county, and the zip. Or it's going to be 2, a manufactured home to be sold with real property. So that's like I own the land, I don't pay rent, I own the land, there's a manufactured home on that land. Okay, and this also goes, just so you know, when it says manufactured home, mobile home applies too. Okay. Because you're not buying like a tow behind mobile home. It's like a mobile home that's made to be on property. Okay, so 1 is rented land, 2 is we own the land. You're going to put the real property situated in. You're going to put the full address there, city, county, zip, and the parcel number, because now it's attached to a parcel. It's attached to a piece of property. Price allocated as follows: mobile home and real property. In case you're like, Amy, I have no idea. All right, if you go to the tax records, it should tell you what the assessed value of the property is, and then the difference between that and the purchase price would be the value of the manufactured home. Okay. Or approximately. You could, I don't know if you can get away with putting like to be determined there. You could put like real property there, whatever's in the assessor's records, and then you could put up here TBD. You might get away with that. Or B. So you've got 1, 2A, or 2B here. A is personal property manufactured home. There we go. B is real property. So you're like, Amy, what's the difference between personal property manufactured home and real property manufactured home? Well, a real property manufactured home, it tells us right here, is one that meets the following requirements. A building permit is obtained from local authorities pursuant to the Health and Safety Code. A manufactured home is affixed to a foundation pursuant to the Health and Safety Code. A certification of occupancy is issued by local authorities, and there is recordation with the local authorities of a form pursuant to the Health and Safety Code. So generally speaking, most manufactured, not most, if the manufactured or mobile homes are always personal property. So mobile home is always going to be personal property. It's generally always attached to the chassis still. Okay, it usually has like a skirt around it. If you look underneath that, it's still not on a solid foundation. Most park homes are going to be like personal property. Okay, because you're renting the land, the personal property sits on it. Most of the time, if it's on a foundation, you can see the raised cement foundation or cinder block foundation that property is sitting on. You couldn't like tow it away anytime soon. It's probably been removed from the chassis and plopped on that property. It's manufactured home. That becomes real property. Okay. If you don't know, if you look at the tax records, it will normally tell you whether it's personal or not, because either it's going to list it. So again, generally speaking, in a park, it's usually personal property. Real property, if you own the land, if you look at the property and it's on a foundation, that usually means it's been removed from the chassis, it's been picked up and placed on the foundation. Now it's become real property. If you look at the tax records, it should say that. It should tell you what it is. Okay. If you have questions and you've got one, let me know. I can help you. Okay, so it's either going to be personal property A in a rented space or sold with real property, or it's going to be attached to a property that you're going to be buying the entire piece of land with the house. It's going to look very similar to a regular house, except you'll see that little seam and usually like a beam going down the middle of the ceiling on the inside. Usually there's a extra piece of wood on the outside covering that seam. It's on solid foundation, manufactured home on real property. Okay. Additional description here is the manufacturer's name. Usually you can find this on the label. There's usually a label on the exterior, usually on one of the ends of the manufactured or mobile home, that tells you the manufactured name, the model, the date of manufactured, and the date of first sale. Sometimes it's hard to find that date of first sale. Is property on the local property tax roll or annual registration in lieu of tax? Okay, the seller should know. Do you pay property taxes on your mobile home or do you pay annual registration fee? Okay. The property shall be registered with the Department of Housing and Community Development. That'd be your HCD, which must be notified upon sale unless property has been converted to real property and title and registration surrendered to the HCD or otherwise specified in writing. Here's where you're going to put the approximate width and the approximate length without the hitch and the expando size. So if it had like pop outs or something, it would go there. Usually this is going to be on the label as well. Usually you can find that information, but ask the seller, they may know as well. And then here is, you're going to find the HCD or HUD license decal number. Again, it should be a label on that structure that tells you the decal number, the serial numbers, and the HCD or HUD label insignia. So this is going to be for number one, right? Because usually we have options of like single wide, double wide, or triple wide. Like how many pieces did they glue together to make this unit? And each one has their own individual label. Okay. I know that's really overwhelming and confusing. It'll all make sense once you have one. I promise. It sounds confusing now. Now, just know, if it is a manufactured home, even if it's on real property, that lender, that appraiser is going to, number one, you need to make sure the lender knows, because sometimes there's different requirements for a manufactured home, even if it's on a permanent foundation, than there are for real properties. And we must have that label information. So you need to find that label before you put the property on the market. Okay, usually it's on the exterior of the building. Sometimes you can find an additional copy of it, like inside one of the closets or the laundry room or something to that effect, if it is like a manufactured home that actually like got converted was made to go on a solid foundation. Sometimes that label, you can find it on the interior of the property as well. So just keep that in mind, but it's usually on the exterior. Items included, unless otherwise specified in the real estate purchase agreement, all fixtures and fittings that are attached to the property are included, and personal property items are excluded from the purchase price. Does anybody have any questions before I continue on? I know that last part was a little bit confusing. Show me raising my hand. I think it'll put my hand down by myself. All right. Paragraph 3D2 of the agreement is modified as follows. Provided the property is or includes a personal property, manufactured home, brokers authorized to cooperate and compensate HCD licensed dealers per broker's policy. Seller agrees that on close of escrow, property shall be free of liens and encumbrances, recorded, filed, registered, or known to seller. Seller agrees that evidence of title to the manufactured home, if personal property, shall be in the form of a duly endorsed, dated, and delivered certificate of ownership, and seller shall deliver the current registration certificate of title as required by law. Seller agrees, if applicable, to deliver as soon as possible to broker for submission to buyer a copy of the seller's lease or rental agreement and all current park and or homeowners association rules and regulations, and to inform broker of any changes either during the listing period. Seller represents that property, if personal property, is either located within an established mobile home park as defined in contract between seller and mobile home park ownership, or that the property is located pursuant to a local zoning ordinance or permit on a lot where its presence has been authorized or its continued presence and such would be authorized as a total and uninterrupted period of at least a year. Seller has not assigned or sublet the property. The foregoing is true. Terms and conditions are hereby agreed to, and the undersigned acknowledge receipt of a copy of this manufactured home listing addendum. Again, if we're listing a manufactured home, we're going to use a special title rep at our favorite title company. You can have a conversation with them about if you're having problems with, like, do you have the certificate of ownership or proof of title of the manufactured home? your title rep's going to be able to help you figure out how to go about tracking those things down. Any questions on our manufactured home listing addendum? All right, that brings us to the end of our forms today. I hope that you got some good use out of this. Hopefully now you've seen this form, you're going to be a little bit more familiar with it in the case that you are listing a home that has a manufactured or a mobile home on it, so that you can make sure to include the correct forms and fill them out completely and in their entirety. If you have any further questions, never hesitate to reach out to me and contact me so that I can get those questions answered for you. If you're watching this on replay, you can throw them in the comment section or contact me directly, and make sure you log your attendance there in the chat box. There's a link to do it, and make sure you make suggestions for what kind of trainings you would like to see over the summer and early fall months as we begin to work on that calendar. Thank you so much. I look forward to seeing you all tomorrow. When we have covered, let's see what is tomorrow. Calendar. Tuesday, we have lead generation basics. So we're going to go over the basics of lead generation tomorrow. That doesn't take away from our lead generation class that we have on Wednesday evening. So on Wednesday at 11, Boomer Donnell with Edward Jones Investments. That was the one I said was last week. It's this week. He'll be talking about your financial future, setting yourself up for success. And if you're going to be in the office, he has lunch for you, I believe. And then on Wednesday evening, we will be covering lead generation on social media. So look forward to that. Thank you for joining me today, and we will see you tomorrow for lead generation basics.